What about John?
I haven't seen John. Like I said, even if we can go out there and we can just pause it for a second.
Yeah.
Just at least so that we.
Yeah.
Hey, Deb, can you just make me a co-host? Good morning.
Yeah, I'm sorry.
That's
Certainly.
okay. Thank you.
Let me admit the rest of these people.
And just
here.
let John in.
Thank you. Okay, I think we've got everyone.
Morning, everyone.
Good morning, Senator.
Right.
Morning, Senator.
Ouch.
We ready to go, guys?
Yes, sir.
Sure, Gary.
Deb, we ready?
Mr. Chair.
Gary works. Just my name. I have to get better about that stuff.
Yeah,
we ready
me
to go, Deb? All right. Let's call to order this meeting of the Judiciary Committee for June 1st, 2021. Good morning. Hope you all enjoyed your long weekend if you got to enjoy it. Any comments from my co-chair? Ranking members?
Nope.
Now we have one item on the agenda, and that is an act concerning labor issues related to COVID-19 personal protective equipment and other staffing matters. That's Senate Bill number 1002. Is there a motion?
Motion for JF, Mr. Chair.
Is there a second?
Second.
Was that Representative Sims?
Yes.
Okay, motion by Representative Stastrom, second by Representative Sims. Representative Conley.
Thank you, Mr. Chair. I have a conflict on one section of the bill, so I'll be recusing myself.
Okay, please turn off your camera and disappear. Representative Fishbein.
Thank you. Good morning. Good morning, Mr. Chairman. I cannot disappear at this point. I do have some questions, though, about the proposed legislation that's before us. Looking at line 14 of, line 14, it appears that one can bring an action for being deliberately misinformed or dissuaded from filing a workers' compensation claim. Am I to understand that that is while the person is still employed by the employer through you, Mr. Chairman?
Through you, I'm the chair. The way that the language is written, I don't see anything that suggests otherwise. Let me check to see if Rep. Porter is on, because she's the chair of the committee, and would be more appropriate for answering a bulk of questions anyone might have. Is Representative Porter on? Yeah.
Good morning. Yes, I am.
Representative Porter, would you like to field questions on this bill?
Actually, I just jumped on, open any questions.
Okay. I think I did answer the question appropriately, but Representative Fishbein, if you want to reframe the question so that Representative Porter can hear, that would be fine.
Sure. Thank you, Mr. Chairman. Looking at line 14 of what's before us in conjunction with lines 12 and 13, it appears that one can bring a claim to Superior Court for deliberately being misinformed or dissuaded from filing a workers' compensation claim. Am I reading that correctly through you, Mr. Speaker? Or Mr. Chairman?
Unfortunately, I do not have the bill in front of me. I'd have to get that. I'm not sure where you are in the bill.
Okay, while Representative Porter does that, my reading is that you're correct, Representative Fishbein.
Thank you, Mr. Chairman. And understanding that there are remedies that are laid out here in the bill. And what remedies would one be awarded by the Superior Court under this language if they brought an action under that clause?
So the
And
so
just
if you look at
yeah.
that,
just to frame the question a little bit more, you know, it appears that that language is inserted in the remedy. Because as we go on, it says that one can get back wages, one can get reestablished for their employee benefits, one can get their job back, but none of those apply to workers' comp.
so Representative, you're correct about where it is inserted in the existing statute. And so it's added on to that language that I think would give rise to the question about the point at which this would happen. And to be clear, your question about whether the person was currently employed or not. So I recognize why you would ask that question.
So I didn't know, sir, if that was an attempt to answer the question, because I'm still trying to link up the two. I'm looking
I can,
Yep.
sorry, I didn't mean to cut you off. Sorry, go ahead.
I'm looking at Superior Court and possible remedy here. This person has been
Right.
dissuaded from filing workers' comp claim. How does the Superior Court look at that? I could see in the labor context, it may be a prohibited labor practice, right? That would be addressed in lines 3 through 10. But I'm trying to frame it in the Superior Court through you, sir.
The only thing that I can give you, Representative, is what is before us, and I think we read it similarly, so I can't give you why. Let me ask this question. Representative Quinn, are you trying to answer the question?
Yeah, let me interject here. Currently under
One second, Representative Quinn, because just to be correct, Representative Fishbein, would you allow for Representative Quinn to answer your question?
Sure, thank you.
Representative Quinn.
Under the current 290A statute, which is wrongful termination in workers' compensation cases, the aggrieved employee has the option of either filing the 290A claim and it be handled administratively by the workers' comp office, or you can file it in Superior Court as a wrongful termination claim. I view what they're doing with this proposed bill as the same thing. So currently you have that option as an injured employee to either pursue your wrongful termination claim through workers' comp or to take it to Superior Court and pursue it as a wrongful termination there.
Representative Fishbein.
Yes, Mr. Chairman, that doesn't address the question. The scenario was, you know, a worker, let's just say they operate a forklift and they fall off of the forklift and they break their leg, but they're still able to work. It is a workman's compensation claim. They go to the supervisor and they say, you know, I would like to file this claim. The supervisor says, well, you know, you really shouldn't do that. I don't know that you're going to get any money out of that. They dissuade the worker from filing the claim. Now, under this language, they have remediable action in Superior Court. They're still working. They haven't been terminated. So the question is, what does the Superior Court do with that? It's not quantifiable. It is perhaps a prohibited labor practice, as I pointed out before in lines 3 through 10, but I'm not aware of any scheme by which the Superior Court can deal with this issue of dissuasion or deliberately misinforming the worker of their rights to workers' compensation. I didn't know if Attorney Quinn, if Representative Quinn had a follow-up given the framing of the question.
Yeah, let me check, Representative Fishbein. Representative Quinn, would you care to respond?
I would still read it the same way, is they're just giving the same option that you would normally have under 290A to either pursue your claim in the workers' compensation forum or pursue it in superior court. And I guess it would be an unfair labor practices claim if the person was not actually terminated. I see that they're adding to 290A the word discipline, which is not in the current statute. So I would gather it would be like any other labor claim that you would have that would not be related to a workers' compensation injury.
Respond.
Yes, thank you, Mr. Chairman. The problem is that the prohibited labor practice is, unless the statute expressly says otherwise, your remedy for that is the labor board. Prohibited labor practices go to the labor board. They don't go to the superior court. They could go to the superior court on a 4-183 appeal, but original jurisdiction of prohibited labor practices is the Board of Labor Relations. So I don't see how this gets inserted in line 13 with that language that says you have the alternative for a prohibited labor practice, which is in this bill in a different section, not addressed right now. But with that, Mr. Chairman, I make a motion that we strike the additional language in lines 12 through 13, starting with or and ending with benefits.
Motion has been made by Representative Fishbein. Is there a second?
Second.
Seconded by Senator Kissel. Is there discussion? So I would, Representative Porter.
Through you, Mr. Chair, I just want to know if we're going to vote on this, is this going to be a roll call vote? Because it is my understanding anything we do to this bill right now is going to kill the bill. We haven't amended any bills in committee, as a matter of fact. So that is the question that I also posed to you.
Yeah, so Representative Porter, any votes that we have on amendments, if it's not called by the proponent of the amendment, I will call for a roll call before we vote. Do you have further comment?
My comment would be that I don't support this, basically, period.
Okay, thank you, Representative Porter. To Representative Porter's comments, I would oppose the amendment. I think that the work that the sending committee, the Labor Committee, has done is work that's had a lot of discussion. It's viewed as important coming out of the committee, and I would prefer not to kill the bill. There is the option to have the discussion about amending on the floor should people choose to, and I would oppose and ask people to oppose the amendment. Representative Fishbein.
Yes, thank you, Mr. Chairman. If I could just know, the chair of the Labor Committee has expressed disinterest or opposition to the amendment. If I could know the basis, because I want to be able to analyze this appropriately, if I could know the basis of that opposition.
Representative Fishbein, I'll pose a question to her. I would guess that it's similar to my opposition, but Representative Porter, would you care to answer?
Through you, Mr. Chair, it is exactly what you stated. At this point, to try to amend the bill in committee would kill the bill. This bill is being worked on, and if Representative Fishbein has an interest in having an amendment to this bill, I'm open to that conversation, but I am not open to amending the bill in committee today. Through you.
Thank you, Representative Porter. Representative Fishbein.
Yes, Mr. Chairman, I will. I do respect that answer. I will let your Mr. Chairman know that I do have, I believe, 8 different proposed amendments to this language. So I understand there may be a running objection, but I'm doing my due diligence. So thank you, Mr. Chairman.
Understood, Representative Fishbein. Is there further comment or question on the amendment before the committee? Further comment or question? Seeing none, Madam
oh.
Representative O'Day.
Thank you very much, Mr. Chair. I'm sorry, I was in and out. Is this the amendment on concerning lines 11 through 15?
That would be correct, Representative.
And could the proponent, Representative Fishbein, just repeat the amendment so that I can understand exactly what we're voting on?
Representative Fishbein.
Yes, thank you, Mr. Chairman. So the motion is to remove the clause from lines 12 and 13, or who has been deliberately misinformed or dissuaded from filing a claim for workers' compensation benefits. And the reason for the motion is it's been unestablished or not established what remedy Superior Court would have to address that, since that's a prohibited labor practice, if at all, and those prohibited labor practices under our Uniform Administrative Procedure Act, original jurisdiction lies with the Board of Labor Relations, and we have not carved out a provision saying that those claims can go to the Superior Court and given the Superior Court the notice, direction, and possible remedy. Remedy is addressed in lines 3 through 10, where those claims go to the Labor Commission. So that's the basis for the motion.
Representative
Thank you. Thank you very much. I appreciate the explanation.
Is there further comment or question on the amendment before the committee? Further comment or question? If not, Madam Administrator, please call the roll.
And this is a roll call on Amendment A. Senator Winfield.
Senator Winfield in the negative.
Senator Winfield's voted in the negative. Representative Stafstrom.
Representative Stafstrom in the negative.
Representative Stafstrom has voted in the negative. Senator Kasser.
Senator Kasser votes no.
Senator Kasser's voted no. Representative Blumenthal.
Representative Blumenthal is parked and votes no.
Senator Blumenthal is parked and has voted no. Senator Kissel.
Senator Kissel is sitting in his dining room and votes yes.
Thank you, Senator Kissel, for voting yes. And from this point forward, I appreciate the fact that you're letting me know where you're at, but I'll try to make it easier on everybody. Thank you, Senator Kissel and Representative Blumenthal. Representative Fishbein.
Representative Fishbein is LOB office votes yes.
Representative Fishbein is voting yes. Senator Anwar.
Senator Anwar votes no.
Senator Anwar is voting no. Thank you, Senator Anwar. Representative Callahan.
Representative Callahan votes yes.
Representative Callahan has voted yes. Senator Champagne.
Senator Champagne votes yes.
Senator Champagne is voting yes. Representative Conley is recusing herself from the vote. Representative Curry.
Representative Curry votes no.
Representative Curry is voting no. Representative Dillon. Representative DeMassa. Representative Doucette. Representative Dubitsky.
Representative Dubitsky votes yes.
Representative Dubitsky is voting yes. Representative Fiorello.
Representative Fiorello votes yes.
Representative Fiorello is voting yes. Senator Flexler. Representative
Senator Flexler.
Sorry. Go ahead, Senator.
Senator Flexler votes no.
Senator Flexler is voting no. Good morning, baby Rose. Representative Fox. Representative Gilchrist.
Representative Fox votes no.
Representative Fox, could you put your video on, please?
Representative Fox votes no.
Thank you, Representative Fox. Representative Gilchrist.
Representative Gilchrist votes no.
Could you please repeat your name?
Representative Gilchrist.
Thank you. Representative Gilchrist has voted no. Representative Godfrey. Representative Harding. Senator Haskell.
Senator Haskell votes no.
Senator Haskell has voted no. Representative Howard.
Representative Howard votes yes.
Representative Howard has voted yes. Representative Labriola.
Representative Labriola votes yes.
Senator Labriola has voted yes. Senator Lesser.
Senator Lesser votes no.
Senator Lesser has voted no. Representative Luxembourg. Representative O'Day.
Representative O'Day votes yes.
Representative O'Day is voting yes. Representative Palm.
Representative Palm votes no.
Representative Palm is voting no. Representative Pablo Tomato. Representative Porter.
Representative Porter votes no.
Representative Porter has voted no. Representative Quinn.
Representative Quinn votes no.
Representative Quinn is voting no. Representative Rabimbus. Representative Riley. Senator Sampson. Representative Sims.
Representative Sims votes in the negative.
Could you please repeat? We're not seeing you. Oh, yes. I see you now. Could you please repeat?
Representative Sims in the negative.
Representative Sims has voted in the negative. Thank you. Representative Veach.
Representative Veach votes yes.
Representative Veach is voting yes. Representative Walker.
Representative Walker votes in the negative.
Could you please repeat?
Representative Walker votes in the negative.
Thank you, Representative Walker. Representative Young.
Representative Young votes no.
Representative Young has voted no. Is anyone else that I didn't get to vote but are here?
Hi, Deb.
Good morning, Representative Doucette. How do you care to vote
Hi.
on the amendment?
Rep. Doucette votes no.
Representative Doucette is voting no. Thank you.
Thank you, Madam Administrator. When you're ready, if you announce the tally.
Okay. 28 people voting, yay 18, nay 10, excuse me, I'm sorry. Yay 10, nay 18. One absent, one abstention, 9 absent not voting.
Madam Administrator, amendment fails. Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I'm still concerned about the fact that we don't know what the Superior Court could possibly do with these cases. If you look at lines 20 and 33 of what's before us, and now that we have brought these cases into the Superior Court, as well as claims against prohibited labor practice claims, we are providing for attorney's fees for employees, but not for employers. And I think it's very difficult to run a business here in this state. I have to credit the entrepreneurs and risk takers that actually do that. And I think that the scales of justice should be balanced in this regard. So, Mr. Chairman, I make a motion that in line 20, after any employee, we insert the clause or employer. And similarly, in line 33, after any employee, we insert the clause or employer to balance the scales of justice. So moved.
Is there a second? Is there a
Second.
moved by Representative Fishbein, second by Senator Kissel? Is there comment or question? Comment or question? Representative Porter.
I thank you, Mr. Chair. I just make the same statement that I made on the First Amendment and every amendment that will be called thereafter. I do not support this process, and I ask that the members of this committee vote no. Thank you.
Thank you, Representative Porter. Senator Champagne.
Thank you.
I'm going to be in support of this. We are passing so much anti-business legislation right now, and this is just another step in that direction. You know, if we're going to be fair, we need to be fair all the way around. And this is not what I see. So I will be supporting. Thank you.
Further comment or question from other members of the committee? Further comment or question? I would just add that Representative Dubinsky.
Thank you, Mr. Chairman. Mr. Chairman, we have over the last couple of months been moving a lot of legislation that gives one side access to attorney's fees in lawsuits and not the other side. And what that does is it sets up a system where attorneys have an incentive to go out and find plaintiffs that can bring claims, even if the claims are tenuous, because they know that one side can get attorney's fees, but the other side can't. And although the claim can't be truly vexatious or truly without any basis, even a scintilla or a thin thread of a basis of a claim is enough for a plaintiff's attorney to grab the claim, go into court, and roll the dice because they really have nothing to lose. We create an unfair playing field where one side has all the benefits. And the only way to really make this a bill that truly protects workers while not throwing the whole system out of whack is to say, okay, if you're going to bring a claim, it has to be a legitimate claim. It can't just be a claim with just a thread of legitimacy, but it has to be a real claim, because if you have a good claim that you believe in, you can bring it, but if you lose, you have to pay attorney's fees. We're by putting attorney's fees in the statute, we're going away from the American model. The American model is that we have an open and free legal system, and everybody has access to it, but you got to pay your own attorney. And what we're doing is we are throwing that to the wind, and we're saying, no, only some people have to pay for their attorney. The other people are on the hook. And if they lose, they pay attorney's fees. Well, what's good for the goose is good for the gander. You can't just say, you can't put parties into court in an unfair playing field. And that's what we're creating here. We're creating a playing field where one party steps into court with an advantage, an inherent built-in advantage that we are creating. And it not only isn't it fair, but it really upends our basic legal principle that the courts are there to fairly judge between disputes between parties, and that each party has access to the same system of justice. By saying that one party has access to attorney's fees and the other party does not, we are upending that system and making it an unfair playing field where one has to pay for their attorney going in, the other is likely to get an attorney on a contingency basis, because that's how plaintiffs' attorneys work. They figure they're going to get their attorney's fees from the other guy if they win. It is not a fair system, and we should not allow this to be continuously written into law. And for that reason, I will be supporting this amendment.
Thank you, Representative. I would just remind the committee that the statute being amended has to currently exist in order to be amended, meaning that we currently have written into the statute, although it doesn't apply to the conversation that Representative Fishbein was talking about, that the attorney's fees would be paid for the actions that already exist. So I'm not sure that I see it as upending a system, because there's a system that currently exists that allows for the payment of the attorney's fees. Also, the notion that a scintilla of a case would mean that people would be more likely to go to court. Again, you would have to prevail in the case in order to get your attorney's fees paid. So if that were the reason that people were doing it, a scintilla of a case probably would not be the reason why someone would go to court. But I recognize the comments of the members who have spoken before me. Representative Callahan.
Thank you, Mr. Chairman. In reading this bill, and I am pulled over for the record, in reading this bill, we've taken a beating over the past 18 months. The employers have taken a beating through COVID. In understanding this committee's cognizance on this bill as well, I understand my ranking member's amendment, and it's important. In this time of uncertainty with trying to rebuild businesses during a time of COVID, the added risk of having to possibly hit by numerous lawsuits and attorney's fees that are derivatives of this bill if it passes, I believe this amendment is important, and I support my ranking members proposing it. And thank you, Mr. Chair.
Thank you, Representative Callahan. Representative Fishbein and Representative Dubisky, are your hands still up, or are you attempting to make further comment or ask a question?
No, sir, I was just, general floor, that's all.
Okay. Representative Dubisky, it's the same true of you? Thank you. So for the reasons I stated, I would be an objection to the changes within the amendment, and ask people to vote against it. If there's no further comment or question, Madam Administrator, would you please call the roll?
And that was amendment B, offered by Representative Fishbein, seconded by Senator Kissel, in lines 20 and 33, after employee, insert in existing statute or employee or employer. Senator Winfield, how do you care to vote on the amendment?
Senator Winfield in the negative.
Senator Winfield voted in the negative. Representative Stafstrom.
Senator Stafstrom in the negative.
Senator Stafstrom in the negative. Senator Kasser.
Senator Kasser votes no.
Could you please repeat?
Senator Kasser votes no.
Thank you, Senator Kasser. Representative Blumenthal. Senator Kissel.
Oh, Senator Kissel votes yes.
Senator Kissel's voting yes. Representative Fishbein.
Representative Fishbein votes yes.
Representative Fishbein voting yes. Senator Anwar.
Senator Anwar votes no.
Could you please repeat?
Senator Anwar votes no again.
Thank you, Senator Anwar. Representative Callahan.
Representative Callahan votes yes.
Senator Callahan has voted yes. Senator Champagne.
Senator Champagne votes yes.
Senator Champagne is voting yes. Representative Connolly has recused herself. Representative Curry.
Representative Curry votes no.
Representative Curry has voted no. Representative Dillon. Representative DeMassa. Representative Doucette.
Doucette votes no.
Representative Doucette has voted no. Representative Dubitsky.
Representative Dubitsky votes yes.
Representative Dubitsky is voting yes. Representative Fiorello.
Representative Fiorello votes yes.
Representative Fiorello is voting yes. Thank you. Senator Flexer.
Senator Flexer votes yes. Votes no, excuse me. Senator Flexer votes no.
Thank you, Senator Flexer. Representative Fox.
Representative Fox votes no.
Could you please repeat?
Representative Fox votes no.
Thank you, Representative Fox. Representative Gilchrist.
Representative Gilchrist votes no.
Representative Gilchrist is voting no. Representative Godfrey. Representative Harding. Senator Haskell.
Senator Haskell votes no.
Senator Haskell is voting no. Representative Howard.
Representative Howard votes yes.
Representative Howard is voting yes. Representative Labriola.
Representative Labriola votes yes.
Representative Labriola is voting yes. Senator Lesser.
Senator Lesser votes no.
Senator Lesser has voted no. Representative Luxembourg has joined us.
Luxembourg votes no.
Representative Luxembourg is voting no. Representative O'Day.
Representative O'Day votes yes.
Representative O'Day is voting yes. Representative Palm. Representative Palm votes no. Representative Palm is voting no. Representative Pablo-Amato. Representative Porter.
Representative Porter votes no.
Representative Porter is voting no. Representative Quinn.
Representative Quinn votes no.
Representative Quinn has voted no. Representative Rabimbus. Representative Riley. Senator Sampson. Representative Sims.
Representative Sims in the negative.
Representative Sims has voted in the negative. Representative Veach.
Veach votes yes.
Representative Veach is voting yes. Representative Walker. Representative.
Some of the medications that he was.
Representative Young.
Senator Young votes no.
Representative Young has voted no. Have I missed anyone's votes?
Representative Walker? Representative Walker votes no.
Representative Walker is voting no. Thank you, Representative Walker.
Madam Administrator, when you're ready, please announce the tally.
"28 members voting, yea 10, nay 18, 1 abstention, absent not voting 9.
Thank you, Madam Administrator. The amendment fails. Representative Fishbein.
Mr. Chairman, looking at section 3, which starts at line 52, if I could ask what the purpose of that section is through you.
Representative Porter, are you on and available to answer the question?
I am on, and he says section 3, I'm sorry, if you could please ask him to repeat the line.
He just said that section 3, it starts on line 52. He wants to know what the purpose of the section is.
This section establishes that workers who got sick or died from COVID during the declared public health emergency, which would be, I believe it was March 10th through April 20th, 2021, are presumed to have contracted this virus at work. And this is an attempt to make sure that they have workers' comp coverage. And it also addresses the death benefit in the bill as well.
Thank you, Representative Porter. Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, as has been pointed out by my colleagues, it's very difficult to run a business in this state. And I find it really troubling that there's going to be an automatic presumption that one who contracts COVID during that time period contracted it at work without giving protection for the employer, an employer that may have followed all the policies and procedures that our government made them do, had PPE and fully outfitted and had rules and, prevented people from coming into the business. And I know, Mr. Chairman, that section sub D starts at line 88, deals with a way in which an employer may be able to show, an action would have to be brought. It says the presumption shall only be rebutted if the employer or insurer clearly demonstrates by a preponderance of the evidence that the employment of the individual was not a direct cause of the occupational disease. I think that's going to be very hard for one to prove. And I know we had a bill earlier in the session, I think it was 5125, which said that an employer was given a level of immunity if they were able to show that they had complied with the governor's rules, the rules of DPH, so long as they weren't reckless or negligent. And with that, Mr. Chairman, I believe the clerk is in possession of an amendment which would replace sub D with a new sub D with sub 1, 2, and 3, and a new sub E. And I asked that she share it on the screen, and very dutifully has done so. And I move the amendment, Mr. Chairman.
Second.
Moved by Representative Fishbein, seconded by Senator Kissel. Is there? It's sorry, it's hard with the amendment on the screen. Representative O'Day.
Thank you very much, Mr. Chairman. And while I certainly understand the component of this legislation, you know, our economy didn't recover from 2008 until January 2020. We were the last state to recover our private sector jobs, the last state in the country. And so that the pandemic has absolutely destroyed our economy, particularly in our service industries. And so I'm begging our colleagues to consider this amendment, if not now, and I understand it will kill the bill, going forward. You might as well turn off the lights, put a nail in the coffin with our economy, and say you know, it's just devastating to our businesses. So I urge my colleagues, if even if you can't vote yes now, we have to fix this. This is just going to destroy our economy. Thank you
Thank you very much, Representative Porter.
Thank you, Mr. Chair. You know, it is already been stated that Section D does allow the employer to review the COVID-19 presumption if they can clearly demonstrate by preponderance of the evidence that it wasn't contracted at work. And the thing that I want to say is this, you know, it is very reasonable to shift the presumption in these situations so that workers who have contracted COVID can be presumed to have contracted the disease at work. When this first started, they were mandated. Service workers, right? Now we call them essential workers. But service workers were the ones that went out, put their lives on the line, put their family lives on the line, and lives were lost. Not to mention the ones who actually contracted COVID and are still dealing with long haul. So we're talking about people that have been out there and made the sacrifices that many of us didn't have to make and still don't have to make if we don't want to, because we've had the luxury of staying home and staying safe. And yeah, our economy didn't recover in 2008. We were the last state. And there's some reasons that I think that happened. And I think a lot of that is playing into what we're dealing with today. You know, unfortunately, you know, these workers, thanks to these workers, we have not had to turn off the light and we have not had to put a nail in the coffin. But there have been bodies, relatives, family, and friends of these workers who have ended up in a coffin. And I think it's really this whole anti-business, anti-worker is what I'm feeling. These businesses cannot survive without workers. We're talking about, you know, we've taken a beating. These workers and their families have taken a beating. And these businesses will be here long after I'm gone. But we are losing people, the frontline workers that have allowed our economy to thrive to the extent that it has, while other folks have not had to be out there taking these risks. And I think this is a very small act. And we have people, constituents in this state that are sitting, watching, and listening. And they want to know, when is it going to be their turn? When are we going to take care of them? And this is the way we're going to take care of them. So I would ask my members today to please vote this amendment down. Thank you, Mr. Chair.
Thank you, Representative Dubisky.
Thank you, Mr. Chairman. Mr. Chairman, before I make my comments, I would just ask if the proponent of the amendment could summarize as to what the amendment does and how it changes the underlying bill. Through you, Mr. Speaker. Mr. Chair.
Thank you, Representative Dubisky. Representative Fishbein.
Yes, thank you, Mr. Chairman. The operative section of the amendment is really the new sub E. which says that no entity may be held liable for any loss, damage, injury, or death arising from exposure to or transmission of the COVID-19 on the premises of the entity during the time period of the COVID-19 pandemic, provided such an entity substantially comply with the applicable health and safety operation guidelines contained in the executive orders issued by the governor and guidance issued by the Department of Public Health applicable to such entity and premises, unless such loss, damage, injury, or death is caused by the gross negligence or willful misconduct of the entity. The balance of the amendment defines operative terms within that paragraph, but the intent is to insulate, to a certain extent, those businesses that actually follow that guidance. The three of them.
Thank you, Representative Fishbein, Representative Dubisky.
Thank you. Through you, Mr. Chair. Do I understand this correctly that if a employer did what the guidance that the state provided for, that this presumption would not attach? Do I understand that correctly through you, Mr. Chair?
Thank you, Representative Dubisky, Representative Fishbein.
Yes, that is the intent of this amendment.
Representative Dubisky. Representative Dubisky.
I apologize, Mr. Chair. I believe I just went through a little dead zone. I didn't hear what the good representative's response was.
Yes, that is the intent. Sorry. Yes, that is the intent of the amendment through you.
Representative Dubisky.
Thank you, Mr. Chair. And if I could ask the good representative, what type of guidance are we discussing here? Would that be under the Department of Health? Would that be the governor's executive orders? Would that be whatever governmental agency oversees that particular field of employment? What kind of guidance are we talking about through you?
Representative Fishbein.
Thank you, Mr. Chairman. Yes, during the pandemic, in an unusual situation, we were given a lot of direction and guidance, requirements, mandates that businesses were required to comply with, including closing their businesses in many cases. It is expressly within the amendment that if the business had followed the guidance of the executive orders issued by the governor, as well as the guidance issued by the Department of Public Health, that they would be able to take use of this immunity. For you.
Thank
Representative
you,
Dubisky.
Mr. Chair. And with regard to that, now, where would the employer provide that information? Like, to whom would the employer need to make a case that the employer followed the guidance provided by the state and the health department through you?
Representative Fishbein.
I think that it would be in the Workers' Compensation Commission, because I believe the underlying language permits these claims to be brought through the workers' compensation process. So a claim is made by an employee saying that they contracted COVID. They would utilize the statute, the presumption that the legislature would create. They would get notice of that claim. Within the procedure of adjudicating that claim and the commission making a finding of liability by the employer, there would be this defense that they had complied, would be my understanding of the utilization of this language. To you, Mr. Chairman.
Representative Dubisky.
Thank you, Mr. Chairman. So once that finding was made that the employer had indeed followed the guidance provided by the executive orders and the Department of Health, does that shift the presumption in favor of the employer that the COVID-19 had not been contracted at the place of employment, or would there be, other than a shift of presumption, would there be some other legal mechanism that would take effect at that time? Through you, Mr. Chair.
Representative Fishbaum.
Thank you, Mr. Chairman. My reading of this language is that these COVID-19 workers' compensation claims are unusual and unique. So while it may buttress that workers' compensation for COVID-19 contracted during that period of time, they are not barred from bringing an action, because we look at lines 104 through 107 of the existing language, which remains untouched by the amendment, and it says an employee who has contracted COVID-19 but who is not entitled to the presumption under subsection A of this section shall not be precluded from making a claim as provided in chapter 568 of the general statute. So to be able to make a different sort of claim, but the purpose of the amendment, so long as the business complied and they were not willful, wanton, or reckless, would be to insulate them from these unique COVID-19 workers' compensation claims. Through you.
Representative Dubisky.
Thank you, Mr. Chair. So if I understand that correctly, there wouldn't actually be a shift of presumption. It would simply be that the presumption in favor of a finding that COVID-19 had been contracted at the workplace would no longer attach. So if I understand this correctly, and I ask that the good representative correct and expound on it if he would. So my understanding is that if the employer made the showing that the employer had followed all of the guidance from the executive orders and the Department of Health, that the presumption would not shift in favor of the employer, but there simply would be no further presumption in favor of the employee. Do I understand that correctly through you?
Representative Fishbaum.
Thank you, Mr. Chairman. Yes, the draconian presumption would go away. Through you.
Representative Dubisky.
Thank you. I thank the proponent for that answer. I have a couple of quick comments on this issue. We are suffering, or at least have suffered, through a global pandemic. Global pandemic. That means that this virus has spread across the world at a pace that we haven't seen in generations. And we have been told over the course of many months that virtually everything we encounter, every person, every surface, every puff of air is a potential vector for contracting this virus. We have been prevented from going outside, prevented from going to stores, prevented from doing virtually every significant act that we normally do in normal life based on this. And it's all because we have been told that COVID is everywhere. COVID is hiding behind every tree. every blade of grass, on every surface, in every building, outside, inside. We weren't allowed, we've been instructed to keep at least 6 feet away from each other because we were told that COVID could be on the surface of somebody's clothing or on their skin, and that if we accidentally rub up against them, we could contract COVID. So this has been a huge pandemic that has encompassed all parts of the world. But what this bill is saying, notwithstanding the transmissibility of this virus, we are going to presume that it's the employer's fault. We're going to presume that the person contacted it at work. Why would we do that? If this virus truly was as transmissible as we have been told, then anybody, whether they went to work or not, could have contracted it anywhere, from any person, from any surface, inside, outside, doesn't matter. But what we're doing is we're saying that we're putting in a legal presumption that this happened at the person's employment. Now, we've heard other members comment that that the economy of Connecticut is in the toilet and is crashing, and that we were the last state to come out of the last recession, and likely we're going to be last here. And it's not because of our people, it's because of our policies. We've had businesses closing left and right. The chair of the Labor Committee indicated that these businesses will be here long after we leave. Well, it's simply not the case. There are businesses that are closing left and right. There have been businesses that have closed, for the last several months. I have had in my own small district, which has very few businesses, many businesses have closed or sold out. Many businesses are having a hard time right now because, frankly, they cannot find anybody to work. And for us to now say there is going to be this presumption that COVID was contracted at work, it's a slap in the face to those businesses who have done everything they possibly can to try to stay open and provide services to the people of this state, while most other businesses were closed down. Now, yes, there are some businesses that were considered essential and were allowed to open, but those businesses didn't have to stay open. They weren't forced to stay open. They stayed open because they felt, the owners of those businesses felt, that the people of this state deserved to receive their services, and the people who were employed there deserved to continue to get a paycheck. So many of these businesses paid out of pocket. The owners of these small businesses paid from their own pockets to pay their employees and to try to keep the doors open, even in many cases when they were losing substantial money. They did this because they felt that the people of this state and the people of their communities were important and deserved to have this service or the ability to buy products at that business. And to now say that we are going to blame COVID-19 on the employer who managed to keep their business open is not only a slap in the face to those businesses, but to every business. And frankly, to everybody in this state who tried desperately to maintain some degree of normality in our system during this horrific time. We should not be penalizing those small businesses that did everything they possibly could to keep open. And for that reason, I support this amendment, and I encourage all of my colleagues to do the same. Thank you, Mr. Chair.
Thank you, Representative Dubinsky. I don't remember all of the conversation that's happened on this amendment. I would just say that I'm going to vote against this amendment, and I would ask others to. There's a lot of comments about what people chosen to do and what they felt the right thing to do was. All of those decisions implicate other people and their health. And I think that this bill is trying to deal with the reality that whether we wanted to exist in normal times or not, we did not exist in normal times. Pandemics are not normal times. COVID-19 was not a normal time. And so that's what this is about. And if we accept this amendment again, to the statements that have been made prior, we would basically kill this bill. And I don't think that is what I would want to have happen. If there are conversations that people want to have on a bill, I think they're appropriate. That's what we do. But I think they are appropriate to have on the floor of the House and or the Senate. Senator Champagne.
Thank you. I'm going to support this amendment, and some of the concerns I have. Number one is, and I guess I could ask this question to Representative Fishbein. Does this cover the employees who were working remotely? If they caught COVID and they were just remotely, would this, without this amendment, would the employer be on the hook?
Representative Fishbein.
Thank you, Mr. Chairman. I believe that employer would have the ability to claim that they workplace during that period of time. However, working remotely comes in various shades. So one can work out of their home and, let's say, be an EMT, on call. They aren't going to the workplace. So this law would automatically presume that the EMT in the course of their work contracted COVID. And I don't know of any test that would give rise to being able to utilize this presumption or the ability to rebut the presumption that's addressed in 88 through 91, because certainly, as Representative Dubinsky points out, COVID is airborne, it's everywhere. So I don't know how an employer could possibly do that. But in answer to your question, yes, there is no exclusion for a remote employee. Merely them being employee gives them that ability to make this claim, and then it shifts to the employer view.
Thank you. Before you continue, Senator Champagne, I want to point you to line 79 through 83 where the exemption exists. Go ahead, Senator Champagne.
Thank you. But I guess my question is basically, all right, so the presumption's on the employer. They have these exemptions, but the employee can still take this to court, and the employer would have to prove that they weren't, they never came into the business. Is that true?
Senator Champagne, I think your question is a question that touches the underlying bill, not the amendment before us. If you want to wait to ask that when we get past the amendment, I'd be happy to entertain that question.
Well, it all pertains to this question as the protections. All right. What about employees who left Connecticut? And this isn't a question, I'm just going to make a comment. The employees who left Connecticut and went on vacation to high-risk areas and contracted it there and then brought it back, or those who refuse to follow the safety precautions when they're not at work. There's a lot of factors here, and to outright blame employer, I believe is wrong. And then what about the employees who have multiple jobs and picked it up on one of the other jobs? Are all employers now responsible for this? Do they all have to defend themselves? I see this as nothing more than another gift to the unions. That's what I see this as. And the employers are going to be left hanging out there. And this isn't just in small employees. This is municipalities. This is even the state government. And we have to be aware that many of these were tracked where this employee actually caught this, and a lot of it was off work time. And at this point, the employers are now going to be left to defend themselves and prove that this happened. But are they going to be available to get the information from the state as to where this was actually contracted from? There's a lot of problems with this. And again, this is just anti-business here. Thank you.
Thank you, Senator Champagne. I would just say that I'm not sure exactly where you have the information that says that many of these were tracked and caught in the way that you suggest. But I think more importantly, the notion that this is just a gift to the unions, I will remind people that the people we're talking about are people who have COVID and suffered the debilitating effects of COVID and or died. And so I don't know that I would frame it as just a gift to the unions. I think we're thinking about those workers who had to go in ways that many of us did not, because we have the ability not to go into work in that way. And I don't think of it as a gift, but if it's a gift to anybody, it's a gift to those who suffered from COVID-19. Representative Howard.
Thank you, Mr. Chair. I had just a comment that I've shared previously with my colleagues that I contracted COVID, as did my family, in November. And as you would likely know, my business didn't shut down during the pandemic. I worked through the whole thing from March, April, May, right, single day, as did, the guys I work with. So I'm not sure how, I'm pretty sure, frankly, that I didn't get it at work. But the only reason I know that is because I know the testing results and medical information of the rest of my family. So regarding this amendment, I'm not sure if I were to claim that I got it at work and we put the burden of proof on my employer to prove that I didn't, how they would do that without access to protected health information of those around me, i.e. my family, friends, people I've had contact with. So I certainly understand, as well as anybody, that, we have to work. I was one of the people working through this, and I understand the concern and the risk that we took. But at the same time, from a legal standpoint, I just think that to put the onus on an employer to do that and then restricting, I hope we're still restricting people's access to protect information, how any employer could ever be successful. I asked that question somewhat rhetorically, but I think it's considered. I think this is a good amendment, and I'll be in favor of it. And I think.
Thank you, Representative. And I'm sure you wouldn't avail yourself of that since you don't believe that. That's where you got it from, Representative Fiorello.
Thank you, Mr. Chair. May I leave my camera off as I'm driving? Is that okay?
You may speak.
Okay, thank you, Mr. Chair. My point on this amendment that I wanted to share with the committee is I know of employers who contracted COVID, and employers also suffered greatly during this time, and they themselves also got sick. As in the early times, we were all struggling to figure out how to function with this pandemic going on. And I don't necessarily have a question, but I want to bring up the fairness of this part of the bill, because we all got sick. And another point I have is, we should also remember that we had many of us who didn't show any symptoms while we were carriers of COVID per se. And I guess it's a question to the proponent of the amendment then. How is it possible for an employee to seek the extra workers' comp under this section who did not show any symptoms, but can later say, actually, I did have COVID and I got it at work? How do we deal with those who didn't show any symptoms? To you, Mr. Chair.
Representative Fishbein.
Thank you, Mr. Chairman. I'm looking at lines 55 through 56. Here's that one who, due to symptoms that were later diagnosed as COVID-19, they may have had symptoms but not diagnosed. I don't even know that under this language that they had to be an employee at the time of making their claim, actually. It's unclear from this. So that's the best that I can answer the question, given the language for us through.
Thank you, Representative Fishbein. I'll just jump in here because I think the scenario set up here imagines someone that never exhibited any symptoms whatsoever. There are many people who had COVID who had no symptoms and had no ill effects. I'm not sure what what one would be claiming in that scenario. I don't think it actually applies, but thank you for the question, Representative Fiorello. You have any other questions?
No, I'm definitely listening to the discussion carefully, and I support my ranking member's amendment. Thank you, Mr. Chair.
Thank you, Representative Palm.
Thank you, Mr. Chair. I just wanted to say for the record that I find some of this discussion troubling because during the pandemic, when so many people hung hearts in trees and put signs on their front yards saying, "Thank you to our heroes," this is time for us to put our money where our mouth is and to uphold those promises that we made, that when those people got us safely through that nightmare, we wouldn't forget them. And I believe that's what this bill attempts to do, and I will support it. Thank you. As is.
Thank you, Representative. Representative Quinn.
Thank you, Mr. Chairman. I think we're going a little far afield here. If someone contracts COVID, but they have a mild case and they don't miss any time for work or don't actually incur any medical expenses, then really the cost to the employer is going to be quite small, if not non-existent. Obviously the other end of the spectrum, but if someone does contract it more seriously, I mean, the costs are going to be much higher. I understand what we're trying to do with this section of the bill. I have concerns over making this a presumption, but I also understand where we are in terms of having to vote, and for purposes of today, I'll vote against the amendment, but I have concerns about making this a presumption as well. Thank you.
Thank you, Representative Quinn. Representative O'Day.
Thank you, Mr. Chair. Just real quick, for a second time, I appreciate it. To the proponent of the amendment, Representative Fine, I just wanted to understand correctly the impact of your amendment on the underlying bill. And I want to give my, all throughout, I wouldn't put myself in mind. So I was, a lawyer legislator going into my office every day, 7 days a week. And I didn't get COVID until I believe my first symptom was the day after Christmas. And I had gone to daily mass. I had gone to work every day, 7 days a week. I had coached football, youth football. Nobody ever got COVID, to our knowledge. Nobody got sick coaching football outdoors. And so my question to Representative Fishbein, in my scenario, would the presumption be that, so I felt ill on December 26th. I went into the office. I ended up going home and sequestering myself from my family and testing positive on the Tuesday following. So in that scenario, under the underlying bill, if I were eligible for workers' comp, would that presumption be that I caught that COVID at work? Through you, Mr. Chair.
Representative Fishbach.
Thank you, Mr. Chairman. Yes, I think it's even broader than that. It says one who died or was unable to work as a result of contracting COVID-19 or due to symptoms that were later diagnosed. So I suppose in this scenario, you could go back to the symptoms that you had in December and then be diagnosed in April or May and go back under this language. The presumption is that you got it at work and your employer's on the hook, the way I read that portion in lines 54 through 56. For you.
Representative O'Day.
Thank you. And so I was very sick. I should have gone to the, I think maybe I would have covered more quickly. Someone I know got sick at a similar time, and they ended up not going to the hospital either. Both he and I were adverse to going to the hospital, wrongly so, particularly in light of the fact that the person I know ended up dying. We got it at virtually the same time. So I guess my question to the proponent of the amendment, under your amendment, under my scenario, I'd have to prove that I got COVID from work, and the person I know who passed away, they would also have to prove, whereas that they got it at work while, if your amendment passes, the burden of proof would be on us. Is that correct through you, Mr. Chairman?
Representative Fishbach.
Thank you, Mr. Chairman. The purpose of the amendment is to allow the claim, but also to allow the defense by the employer that they reasonably complied with the rules of the government and that they were not wanton, willful, grossly negligent, willfully misconducted their policies and procedures during the pandemic. So it doesn't get rid of the ability to file the claim by the worker. It just obviates the automatic presumption. I think that addresses the question for you.
Representative O'Day.
Yes, that does. Thank you. And so it would be like the McDonnell Douglas burden shifting, or would it be different through you, Mr. Chairman?
Representative Fishbach. I don't think it's a burden shifting, but it balances the playing field. The presumption that is created by Section A and the ability to rebut that presumption, that ability has a very high bar, in my opinion. The employer would have an affirmative responsibility to prove that the employee did not contract the COVID-19 from their business, which, as stated previously, is virtually impossible to prove. So this gives the employer the ability, something that is attainable, by saying we comply with the government regulations and therefore we should be protected, at least from the workers' compensation claim. Through you.
Representative O'Day.
Thank you, Mr. Chairman, and I thank the good proponent. The good representative who preceded me about, keeping our, we've had these our first responders working and keeping our word. I don't disagree with those comments and sentiments, but in one sense I agree with them. But in another sense, at the end of the day, we need our employers to grow and prosper. We need employees that were buzz-free at work to be able to be compensated from their injuries at work. But in a global pandemic scenario, stacking the deck such that making it impossible, I think this underlying legislation makes it impossible for employers to those that acted the right way, that stayed open when needed, that provided services when needed, they're potentially going to be driven out of business. So I think we've got to weigh a lot more than just one side on this. And I urge my colleagues, if you can't vote for this amendment now, please vote for it when it comes before the House or the Senate. Thank you very much, Mr. Chair.
Thank you, Representative Callahan.
Thank you, Mr. Chair, and I thank my ranking member for and the proponent of the amendment. Being someone who didn't miss a day of work during the pandemic and had to look out for several staff members, we took every opportunity we could to make sure they were safe during the pandemic. However, there were still some, even being sequestered in their own office, that did contract COVID. It would be extremely difficult for me to prove that it wasn't my fault or my agency's fault that these people that were taken care of with PPEs, only partial staff coming in, different days of the week. As a small business owner, I'd be scared to death that I'm going to be responsible, even if I've done everything in my power to make sure they were safe. Now, unfortunately, in a small business setting in Connecticut right now, I would be afraid around every corner. And I understand the chair of the Labor Committee. I certainly understand her position to protect employees, but we had several employees that were very safe and very careful. But we also had people that were working remotely that we later found out they were traveling to other states. They were engaging in activities that were unsafe, but that would put the onus on me to prove that. So I just think that's it's a good amendment proposed by my ranking member, and I urge the committee to support it. And I thank you for your time, Mr. Chair.
Thank you, Representative Callahan. I just want to point out that under the scenario, if those employees were just working remotely, they would not be covered by this section. But we take your point. I see hands that have been up in the past. I'm not sure if they're still up, so I will go through each individual. Representative Fishbein, is your hand up? I'm sorry.
Thank you. Yes, Mr. Chairman, just briefly. Mr. Chairman, I've heard a few times this morning about procedure and where we are. And I've reviewed the procedure for this bill. There's been claims in opposition to the amendment saying we're going to vote against because it's going to kill the bill. Can I just know where that representation is coming from? Because it appears that the Senate never voted on this bill. So what is the basis by which one makes that claim?
It is the time that it would take for the bill to get back to the chamber after being amended in the committee.
So what would be, in good faith, once the committee approve, if we only amend things that are within our cognizance, and then it goes to the Senate calendar, what would preclude the Senate from then voting on it and then it coming to the House through?
I think the concern is that it doesn't go immediately back onto the calendar. And I think, as you know, even a day's delay at this point in the session is dangerous, but several days would be a killer to the bill. So that would be the concern that has been raised by several of the people today, Representative Fishbein.
Okay, thank you. Now that I know that. And the other thing was, I guess a question for Representative Porter as the chair of the Labor Committee.
Representative Fishbein, let me just ask you this question. We are on the amendment. Is the question about the amendment, or can we ask the other people who have their hands up and then come back to you?
Sure, we can come back. That's fine.
Okay. Representative Callahan, is your hand still up, or is it up for a new question or comment? Representative
Sorry,
Callahan.
Mr. Chairman, this is Representative Dubitsky. Did you just call me?
No, I called on Representative Callahan. Your hand doesn't seem to be up currently. Okay. Are there any other comments or questions on the amendment that is before us currently?
Yes, Mr. Chairman, Representative Dubitsky.
Yes, Representative.
Okay, a couple of quick things. First off, one of the representatives from the other side of the aisle previously indicated or discussed that a employer would not have a significant burden if the employee didn't have a severe case of COVID, and therefore didn't miss any work. I know that we're kind of getting out of the pandemic now, but I want to bring everybody back to about 2 or 3 months ago, when if somebody tested positive, meaning that when they went to get a test, some COVID cells were found in their nose, whether they actually contracted the virus or not, they were required to quarantine for at least 10 days. So there was no such thing as a mild case, because even if you had no symptoms whatsoever, you still had to quarantine for 10 days. So you still very often couldn't work. So, a mild case really means very little when it comes to COVID, under the rules that we were told we had to obey. So I really, I have a hard time with compelling a employer to have the presumption that the case was contracted at the employment. In the event, we don't have mild cases. We have, every case was severe enough to stay out of work for at least 10 days, in some instances more than that. The other issue that I think is very relevant to the issue of the presumption is, how does an employer rebut that presumption? And one of the problems is that, as my colleague indicated, the employer is not going to be able to find out if the employee's family or friends or other people living or interacting with that employee had COVID. So if the employee's entire family was quarantined or even had severe cases of COVID at home, and the employee clearly contracted the virus at home, there's virtually no way for the employer to find that out because of HIPAA rules and such things. So there would be really no way to effectively rebut that presumption that the virus was contracted at work.
Representative Dubitsky, the House has gavelled in, so we are going to end the committee. Thank you all for participating today, but we cannot continue since the House is already gavelled in.
Thank you, Mr. Chair.
Thank you, Mr. Chair.
Thank you.